Yeah, hi. So I'm Uwe Schindler, and this talk is about the legal aspects, especially about copyright for data, but also about software. And wait a minute. Now, okay. So my background here in short. So I'm part of the Pangea team at Marum University of Bremen. I was one of the founders of the Pangea database. So a lot of that code base is written by me. I studied physics very, very long ago, so I'm not a computer scientist. And I'm responsible for the metadata processing and the search engine of Pangea, which is based on Elasticsearch. And due to that special course with using search engines and Elasticsearch, I'm a long-term open source contributor. I'm a member of the Apache Software Foundation. So I'm taking care of many projects relating to full text search engines. I'm also in the management committee of Apache Lucene, Apache Solar, Apache Tiger, which is used for text extraction, Apache PUI, and also Elasticsearch. And that's also the reason why I'm working a lot with licenses and legal aspects. And because of that, I agreed to have that lecture here about licenses, because I can give you some background about for example, how it works in software licensing, and how that can be transferred over to data. The most important thing is I'm not a lawyer, so everything you hear today cannot be used for any legal decisions that you want to take. So if you have any questions, ask a lawyer of your institution if you need to get more details about data publication. So this is just more an overview how to license data and so on. Let's go what I'd like to talk about in general. So the first part of the lecture will be in general about the term intellectual property, what it means, and all those special terms around that, like licensing. Sometimes copyright is an important term. Trademarks, of course, the authorship of data sets or publications, the invention that's inside, also brands. This is all related to intellectual property, and this also applies to data sets. So what are the problems with those intellectual property? So basically what you have is that the scientist worked hard. He did a lot of science, and at the end, the scientist wants to publish the results. And he wants to prove his investigations in papers. So actually, he wants to make everything freely available. But on the other hand, the scientist, in most cases, wants to protect, I call it somehow, his or her data, because that's already questionable, because it's not his or her data. But if you're talking to a lot of scientists, it sounds like that. It's my data. I did something with it, and I don't want to give away that data, but I still want to prove my investigations in papers. And that's what a lot of older scientists are doing. And that's the reason why a lot of data is not visible, because somebody else could do and use it instead of the scientists to figure out something new from the data that the scientists didn't know before. And that's actually why scientists want to have some protection. What can people do with the data of that scientist? That a little bit later is in the meantime already also copyrighted work. So software is copyrighted, data is harder. So the problem of the scientists is the scientists do not need, and indeed in the scientific world, they should not have the exclusive control over who can copy their papers or the data and who can make derivative work. So derivative works means somebody is using the paper or the data and create something new out of it. So actually in the scientific world, we don't really want to have that, because others should be able to freely do with our data whatever we want. So actually, in our case, the copyright law is doing a little bit too much for us. And that's the reason why we need licenses. So the solutions about that is you need to declare the right to share the knowledge in papers and data, and you want to give the right to study to everyone. So not only scientists, also if it's a user at home and he reads the paper, this person should also be able, and it should also be companies or whatever you want to use the study, the knowledge out of papers and the data. And there's one solution which is generally, because we had previously we had the copyright, and there's something like the inverse of it, which is the so-called CopyLeft. And there's also, funnily, there's a Unicode symbol for it, so you can also copy and paste it into your paper if you like. So there's Unicode code for the copyleft symbol. So actually the copyright has a small gap in the C on the right side. So this one is inverted and has it on the left. And this is somehow the opposite of the copyright. And where this comes from, I will tell you by looking at open source software licenses in your case, because the open source software already did what's now going on with data. And they invented licenses to actually turn the copyright into that copyleft or something in between. So that's basically the idea what you are doing with the license. You explicitly declare, I don't want to have the copyright applied to that, or better, you say the copyright is applied to that work, but I want to change it a little bit by giving the users using that software, in that case, to do whatever I declare in my license they can do without infringing my copyright. So the history of that was that in the early time of computer software, that was also done by academics in the 50s and 60s, they were developing software, and at this time, the software was not falling under the copyright law. So actually, at that time, there was no licensing, no ownership, and nothing. So everything that the scientists did in the 50s and 60s regarding software was completely open. So it was somehow public domain. Everybody was able to do everything with it because there was no regulations about copyright or anything like that. So for the scientists at that time, this was perfectly fine. And this is where the Unix operating system came from. So originally, the original versions of Unix were all completely free because there was no law which applied copyright law, as we have seen before, to software. But unfortunately, in 1974, there was a commission on new technological use cases of copyrighted works that decided that computer programs, to the extent that they embody an author's original creation, are proper subject matter of copyright. And from that time on, of course, there was a lot of lobbying included because there were software companies. Microsoft was not yet there, but there were other large, like IBM. And so they wanted to have the software they created in somehow a closed approach be copyrighted. And they succeeded with that. So unfortunately, software is now under the copyright, which is on the other hand, good, because there's an ownership on software. And there's one responsible person, the owner of the software, who can decide what others can do with the software. But on the other hand, they also can earn money with it. And that's what companies like Microsoft, IBM, and all of those were doing a little bit later. And the problem already existed for some time, and a lot of you from those people have seen that person already. In 1983, there was the first idea to somehow reverse that copyright law to make a copyleft out of it. And this was founded by Richard Stallman, and he campaigned for software to be distributed like in the former times in a manner so it can be that all the users receive all the freedoms to use the software. So you should be able to use the software without paying any money, you should use it on any device you want to have or whatever. You should also be able to study the software, so the ability to understand what the software is actually doing. And you should also be able to distribute the software. And once you figured out that the software has a bug or whatever, it doesn't work like you want to have it, he also wanted to allow modifying that software. So, and this is basically what the CopyLeft, as I said before, was made for. So those are the free software principles that were invented in that time around the early 1980s. So the freedom to use the work, the freedom to study the work, the freedom to copy and share the work with others, and the freedom to modify the work, and the freedom to distribute modified and therefore derivative works. So you can read that on the Free Software Foundation pages. When you look at the GNU license, you can get those free software principles. That's basically the idea of the original free software license, which was implemented or somehow not implemented. He published that first license in his GNU manifesto. GNU means GNU is not Unix, because at that time Unix, the operating system, was very, very licensed to companies like IBM, Berkeley Software, whatever. It was very, very, and he wanted to create a new software that is not Unix anymore. And so this GNU comes from GNU is not Unix, which is something like a strange acronym that contains itself. So GNU is not the public domain. So basically, he also wanted to say, okay, there's one reason. What you could do is you could say, okay, the work is copyrighted by my own, but I want to say, I don't care about the copyright, do whatever you want with it. That's also one type of license. We will see a little bit later when we are coming to data licenses, Creative Commons licenses, which is, I don't care at all. I have the copyright, but I, as the copyright owner, say, do whatever you want with it. So he didn't want to have that. He wanted to have a bit more restrictions on it. So he explicitly said what people can do. Everyone will be permitted to modify and redistribute the GNU, which is the software package, but no distributor will be allowed to restrict its further redistribution. That is to say, proprietary modifications will not be allowed. I want to make sure that all versions of GNU remain free. Basically, that's what all of you know from the GNU Linux software package, the Linux kernel. It is not allowed to create derivative work or something like that, which is a modified Linux kernel, and then make it restricted. So you have to give out the source code to everybody else, so the other versions can look at the source code. So this license is very, very specific on that part. And this is, we come back to that a little bit later. It's also a problem with the GNU license, the original one, because it's often a little bit bad for software companies that want to protect their own work, because whenever you change anything in the Linux kernel or modify it a little bit, it happens that you have to make everything, also your derivative work, freely available. And then you cannot protect your own work that you have spent into that software on your own. You cannot protect it anymore. And this is one of the problems of the GNU license, and why there are often discussions with router manufacturers that do not correctly make all their software that they have on the small router you have in your Fritzbox or whatever at home freely available. And because of that, there are often license issues with them. So actually, you have to keep that in mind. I will come back to that, but how that license would be applied to data later. So, and this is now somehow the move to those licenses which are developed by using the by using the GNU licenses, and there are also some other software licenses. So the software industry has created other licenses which are not so restricted like the original GNU license. So there are different types of licenses. I will show them at the end of my talk what that means for software. But the more general part is the so-called Creative Commons licenses, which were a transformation of those pure software licenses to artistic work like photographs, books, pictures, or whatever. So those Creative Commons licenses, there are many of those licenses. So you will find a lot of terms in here that you have heard before already. So the full list of Creative Commons licenses, if you go to the bottom here, you have that all rights reserved, which means you have the copyright, nothing to do, but nobody else is allowed without asking you to do anything at all. So basically, that's most restrictive. So by default, nobody can do with the work. It can be software, data, or papers, photographs, or whatever. And then there are other licenses, and there's one license which is the CC0 license, which is most open. And this license basically is what I said with public domain at the beginning. It's basically, I don't care, everybody can do whatever I like with it. And there are some special licenses regarding if you can remix it or not remix it, if you can share it with everybody, if you can change licensing or whatever. So I will go through that list now and show you. So basically, the important thing is now in the EU especially, but also in the US, if you see it a little bit different from what you are protecting, the data set or the constellation of the data set, how it is formed, can be protected. So you cannot for data, you cannot protect each single data value, but the combination of data values and the structure of the layout, how it is constructed. So for example, if you have a database, you can protect the table names of the database, but you cannot really protect the contents of those tables. That's basically what you have to keep in mind, but all those of the Creative Commons list applies to your work too. So let's start with a simple license. CC0 is very, very simple, as said before. It's also the shortest license. So applying it is very, very easy. And the cool thing is it works almost everywhere on the world. So because it's so simple, because it only says more or less, I don't care anything, there are no rights reserved, and there's no copyright applied to that work. So basically the license simply says, no copyright on that work, you can do whatever you want with it, period. Okay, in legal English, it's a little bit more than that, but basically that's all what needs to be said. So it's not even a requirement to have attribution on that software. So basically, if you have something with CC0 published, anybody else can use it without even mentioning you. That's something you have to keep in mind as a scientist. So you give it away completely without any requirements. So it's not even needed to cite yourself about that. So that's often misunderstood for the CC0 because a lot of data centers use CC0, but I will tell you a little bit more or less. This is more or less somehow not really the legal text, but it's a legal explanation about the CC0 license. So it just waves away all their copyright in some legal words to the fullest extent allowed by law. And because it's so simple, it can be applied into particularly all legal jurisdictions that we have. There's one small Kleingedrucktes on top of it. Not even CC0 can guarantee a complete relinquishment of all copyright and database rights in every jurisdiction, but we, in that case, the Creative Commons organization, believe provides the best and most complete alternative for contributing a work to the public domain, given the many complex and diverse copyright and database systems around the world. So actually, the good thing with the licenses, it's so simple and applies almost everywhere. I don't know where it does not apply. So actually, everywhere it works somehow to tell anybody, I don't care. I don't want to have my work protected. Here, you have it. Do whatever you want with it. That's basically what CC0 is. And you can apply that to your work, but CC0 is in the scientific work, you still have to keep in mind that if you are a scientist should cite others' work. So basically you can say, okay, here's the data available. The owner doesn't say, you have to cite me. But the good scientific practice still means that if you use others' work, you should cite them, but it's not part of the license. So with applying the CC0 license, you don't have that requirement to cite you, but the good scientific practice still wants it from the user of your stuff. So basically, in my personal opinion, that's the easiest license that you could apply, because it's very, very free, it's very, very simple, works everywhere, and you still say, okay, I'm enough, because in the scientific world, if anybody else uses my work, they have to cite me anyways, so I don't need to put that into the license. That's basically, if you look at that from the scientific point of view. But there's another license which does a little bit more. So this is the so-called CC-BY license, and BY is a shorthand for by attribution. So the other half of all those data centers recommend you to not use CC0, but on the other hand, CC-BY, which is just the license, which is already a lot of pages more. So the CC0 license is only one DNH4 page. The CC-BY license is a lot longer because of that crazy constellations to make that attribution required, and also something else. And therefore, it's not so easy to apply in all the countries, but it requires anybody to do attribution. So the data, in that case, the data, if you see that CC-BY on data or a paper, scientific paper, you can use it in your own work. The data is freely available. There are no limitations, but the usage requires to cite, or in the legal terms, attribute the original authors of the stuff. But there are no further restrictions on the usage. And here's, for example, one data set in Pangaea, which is here with the Creative Commons Attribution 3.0 license. So this is, for example, how it could be applied to a data set. In that case here, it is the version 3.0. I will come back to the other versions too. There's also version 4.0 at the moment, but this is an older data set. I used that on purpose here, because there's also the special term of unported behind that, because one problem of those CC licenses is that they have different variants for specific jurisdictions. So there's a explicitly German one of CC BY 3.0, which is only for the German legal, and the unported one is for all of them, but it's not so good with connecting. And the new version 4.0 has no country or legislative specific version. So basically, when you publish a data set today, you should lose the 4.0 licenses, because especially for data, the 4.0 is better in that case. But here you see in Pangaea, we have a lot of data sets with 3.0, because the reason is the data, in that case, we have no copyright transfer to Pangaea. So the owner of the data is still those persons you see here in the citation. So unless those say they want to change the license to the 4.0, we are not allowed to do that on our own. We are planning as a data center to change our terms of use a little bit. That allows us to update licenses in the future, but this would still not apply. So explicitly to change that license, we as a data center have to ask the owners of the data set if they agree in updating the license, or they come to us. So that's one thing about the version numbers. I would recommend for you to use the 4.0 licenses nowadays. So the attribution is a little bit special, and this is also a little bit a problem of the CC BY license, because for scientific usages, it's a little bit strange when you apply it, because the term attribution is, you see here, it's already almost a teenage 4-page about the attribution. So there are some very, very specific restrictions which cannot be applied in scientific work easily. So the first one is identification of creators of the licensed material and others designated to receive attribution in any reasonable manner, blah, 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 blah. This is easy because a scientific citation contains that, because you have the names of the authors of this of that thing. It's perfectly fine. The second problem is if you share the licensed material, that the copyright notice must be shared. That's something you would normally not do in a scientific paper. In your citation list, you would not write. So basically, this is a little bit problematic on the conference, that you have to explicitly share the copyright notice, because as you said before, if you don't apply a copyright notice from the beginning, you cannot share it when somebody else is using it. So basically, the recommendation here is, don't explicitly put that copyright symbol on your work, because otherwise anybody that using it must preserve that copyright there in its own thing. So that means also it needs to be done on all the derivative work that come out of it. That notice that refers to this public license, this can be done in scientific papers for data, for example, in the data availability section, where you normally say that data set uses data licensed under whatever license, so the public license, but you can't put that into the citation itself. A notice refers to disclaimer of warranties. We don't have that normally for data sets. And the most important thing is you have an URI or hyperlink to the licensed material, and in that case, that's the DOI. So basically, if you apply the CC BY license, you also require that the data is linked with a DOI or whatever, a link, so you can download it. If you just cite it there without a link, you would be citing it in a wrong way, because you don't have a direct link in that work. So basically, that's very important. So the attribution is a little bit too specific for scientific work, because it's really more for the business use cases where you have to state all those legal terms like copyright and whatever. So basically, CC BY is good because it requires attribution, but the attribution is a little bit more than just citing the stuff. You have to keep that in mind when you're using CC BY licensed data, but actually, nowadays, the recommendation is still use either CC0 or CC BY for publishing scientific data. And these special cases with copyright can all be somehow circumvented. So the most important thing is correctly cite data that you have used by anybody else. The same applies for software and, of course, written stuff. So that's about that. So keep in mind, citing and attribution are different things. So the attribution is a little bit more. What we see here is CC BY SA is exactly what we have seen before with the CopyLeft licenses for the software. So that means when you apply the share alike, you're restricting everything must be completely open afterwards, and it cannot be restricted. So the distribution cannot be somehow the derivative work that was written in that paper and somehow published under the paper must be under the same license. Otherwise, it would not be accessible anymore, the derivative works. What are the problems of that share alike? Anybody using this data for his own work needs to use the same license. So what does it mean in the scientific context? There's unfortunately the impossibility to publish a paper with a figure or diagram analysis or whatever table based on licensed data in a known open access journal. So that means if you put the share alike license on your data or on something, it doesn't mean to be data, it can also be software, or it can be a paper in an open access journal, any derivative work from it. So for example, an analysis of the data cannot be published or shared by somebody who wants to cite you in a non-open access journal. So basically, SA-like data cannot be published in a closed shop Elsevier or Nature journal. Do we really want to do that? Actually, there's a workaround for that, but you have to keep in mind, if you share your data with share alike, be prepared that all persons who want to use your data will send you an email asking for the permission to use your data in the work that is published on a closed access journal. So that's the thing that you have to keep in mind, but it's also a good possibility to somehow restrict your work that it can only be used in open access journals. That's a good thing, and this is also a good idea for journal publishers which have open access journals to have the journal article in CC BY share alike, but most of them don't do that because otherwise they couldn't be easily cited or whatever be used from still closed access journals, and in that case, most people don't use the share alike for that, but you have to keep that in mind. You can do that with your data if you want to enforce completely free availability of everything. So basically, this is an additional restriction which limits the usage of the data. It must be under the same license. There's also another license available. It's only shortly here, CC BY ND. ND means no derivatives. As usual, there's citation required. Data can be used for own publications, but it must be shared unmodified. And you see here, it almost makes no sense for data, because if you want to use data, you have to somehow modify it and share it somehow, the results of the data in a modified way, which makes for data no sense at all. The license CC BY ND is mainly used for artistic work. So for example, an image or a logo, if you want to publish that everybody can use the image or that logo, you are somehow restricting that usage of the logo, that it's not allowed to modify it when republishing. That's basically what a typical photograph where they have this künstlerische Freiheit or whatever, and they want to have the logo always appear in the same way. They don't want to have derivatives of that logo somehow where the color changes or whatever. For those persons, CC BY ND is useful, but forget about it for data. So this is very restricted. So you cannot crop filter data, no compilations, sharing needs to be also in the original form. So there's also not really clear what happens if you change the file format. Is it still allowed? I don't know. For photographs, it's somehow declared. It doesn't matter if it's a JPEG or PNG, but in general, you have to be very, very careful with this no derivative. So, and the last one of those licenses, all of those that we have seen before can also be combined with something which is called non-commercial. So if you look at that, it looks almost correct for scientific data or scientific software, because the scientist always thinks, oh yeah, I have found out something, or I was going with a ship paid by the taxpayers. So if I use that ship the taxpayer has paid that. I don't want to have companies using the data that came out of or the software or whatever. So that's what most people have in mind when doing something like that. But the problem with this NC is it doesn't really help in that case, because it prevents use of the data to develop commercial products. So the people think, yeah, there cannot be a commercial product created out of it. It also, most people think it prevents selling of the data or the software to third parties. Yes and no. The problem here is that's what people wish to do. And in any case, it's also not the correct thing to do. If you think about that, scientific work is for everybody. So if you're doing scientific work, you have figured out, you have created a data or a table, the taxpayer has paid for it. But the taxpayer is not only persons, it's also companies. So basically, every company should also be able to access the data. So by limiting that, the usage to companies is not really a good idea from the scientific point of view. And because of that, the founders of our projects normally forbid to use non-commercial licenses for outcomes that are done in the project. So they require you to use CC0, CC BY, CC BY SA licenses, but not non-commercial licenses, because there are more problems than they have, because actually NZ means in reality a little bit more, and there were also some problems on the court about that. So some companies had problems with the commercial license. So it doesn't really work well, because the definition of commercial is completely missing in the license text, and the information about them is more or less about it disallows fee for sharing or hosting the data. So actually the data center is not allowed to, for example, provide downloads of the data set against money or something like that. It's not even allowed to have advertisements on the repository's homepage. But in any case, if somebody wants to use your data, they can still do it. They can still simply not publish it anymore. But there's nobody that prevents a company from using the data, creating some new product out of it, and not maybe only mentioning you in that, but the new product, it cannot really be protected. So basically, it doesn't really help you to protect the non-commercial. If you want to publish your data, there are two other licenses which could be used. There's also the Open Data Commons Open Database License, ODBL, which is more or less CC BY share alike, and there's the Open Data Commons Attribution License, which is more or less CC BY. They are not commonly used because CC BY in its newer versions also applies to data. So you might find older data sets with that, because those licenses were specifically written for data, but they are no longer needed, because if you're using CC BY 4.0 or the other licenses, it's much better to use. In one of my next slides, I will have some combination matrix, what licenses you can combine to each other. But actually, if you have proprietary licenses outside, you have to find the closest or best fitting license between them. And if it's mostly homogeneous data that you're putting together, just use the same license that they were using with some additional restrictions. But if it's very diverse data, then you have to ask a lawyer, I have the feeling, if it's compatible to put those licensings together. So yeah, finally, maybe let's go on with the last few slides and to show about mixing licenses to each other. So actually, your problem is really a problem of the users, how to put together data with incompatible licenses. And for that reason, it would be good if all of those data sets use something like a common license. And this is why the open society, the scientific society somehow said, if you're sharing data, use CC_BY or CC0 because those are compatible to each other. So the result can also be CC0. So don't use CC&Z share alike or whatever, because it really makes it complicated. And that's also one other reason why you should prefer the more open licenses. But of course, if you're a consumer of data and the others have already decided, it's a hard task to do that. So actually, if you look at the statistics, you see those statistics are from, I think, 2014. Unfortunately, the Creative Commons homepage have not yet updated those statistics. So 76% of all data sets, of all public content on the internet allows remixing, and 58% allows commercial use. But this, of course, includes images and whatever in that. And there's also a large grown from the free culture licenses, CC0, CC_BY, and CC_BY share alike. They are called free culture licenses. And those raised from 40% to 56% in 2014. Basically, the usage of those, although in the open internet, goes up. And one main reason for that is, of course, Wikipedia, which is using the CC_BY share alike license in that case. So everything that you are using from Wikipedia needs to be as open as the original Wikipedia. So, and finally, some recommendations. Which CC license for data? We already talked about that. So use for data one of those on the top, which is the free culture licenses here. And I have a little bit of a problem with the share alike license because it somehow prevents users from using the data to create compilations which should be published in combination with closed access journals or something like that. So if you do that, you enforce anybody out there to publish their derivative work in some data center which allows open access with one of those licenses. And the other problem is share alike licenses are very, very hard to combine with other licenses which do have any special have restrictions on top of it. So something like the example said before, they are very, very limited licenses, very, very open licenses. You cannot combine them together. And then it happens in the same way like with the Apache Software Foundation, which does not allow to have specific licenses in the source code because they are incompatible to each other. So the other thing is, I talked about that already, which CC version to use is at the moment. If you're sharing with Creative Commons, it's version 3. There's version 3 available, which is mostly suitable for literature, suitable for data in most countries. And the problem with those is country-specific variants versus some unported version, which is not as clear in the legal text. And the more modern version, which is version 4.0, which contains the European sui generis database rights, as said before, so you can somehow protect the setup of your database, which means the setup of the data set, like the attached metadata, how the matrix looks like, how the data is arranged to each other, and so on. So this can be protected, but still you can't protect single data points. That's one thing. And this, for example, is in the Pangea database where I'm working for the new default. And here are just the sui generis database rights. I don't want to give them in detail. It's basically the information about the legal constraints, how to define what the database is and how it is protected. So, and now finally, about the question that I had before here with the remixing data. So actually, this shows somehow a matrix. If you have data sets from one specific license, how you can combine it with other licenses. So for example, you can here CC BY share alike can combine with CC BY with all those. But of course, you always need to use the closest license at the end, which you use. So if one of your data sets is share alike, the result must be also share alike. But for example, you cannot combine CCBY data with non-derivative data because you cannot combine it at all, for example. That's one of the problems because non-derivative means you cannot change it anymore. So actually, this works well for remixing data, but it doesn't solve the issue. I think, Ryan, it was your issue about how to combine proprietary other licenses which were written by some persons who published the data on their own by some large data centers. This is very, very hard. And in that case, what you can do in most cases, you can ask those if you are allowed to share, because they are the copyright owner, they can decide if they give you the right to share the data that you have created as a result or as a derivative work in using the CC BY license, for example. You can ask them, and if they say yes, it's okay. So basically, when you're combining licenses, you can always ask the original license owner, which is a copyright holder, if they allow you that you combine that in another license. But then you have to put that into your Aktenordner and don't forget that. And then you can forget about it, but you have to keep it in case of some court issues. You need to have that statement. Yes, I'm granting that my data is reused in modified form in a CCBY data set. That's one possibility that you could have. So in all cases, it's asking, it's bringing legal trouble, but that's the only way to solve that. Okay, and how about software? That's somehow also part is. So one important thing is, if you are publishing software, the recommendation is to don't use CC licenses because they may fit for software, but the problem is software has a lot of more problems with intellectual property that needs to be protected. So the CC licenses are not fully suitable for that. Because, for example, one of the problem is issues when, for example, somebody is using your software and suddenly the house burns down because of that software. There is no information, so it could be that you are liable for it, and because of that, it's better to use a software. If somebody is using your data, it's very unlikely that the house burns down. It could happen, but it's very, very hard to bring that together with your data. So in that case, it's not a problem, but for software, it's an actual problem. And the other issue with software is, on software, you can have patents. And unfortunately, with patents, you have to be very, very careful. And for that is you need software licenses which tell you, which tell the end user how to deal with licenses. And something else also in software, which is interesting, they also have some information about how the communication, the development community should behave, and so on. So there are actually some additional clauses in those licenses which might be useful. But if you just want to have a general overview, the most well-known from the press is a GPL license for software, which is, as explained before, the CopyLeft license. This one is basically equal to CC BY share alike. That's basically how you could compare it in the whole thing. And the other software licenses, which are coming from the which are, for example, the Apache 2 license, that's the foundation I'm coming from, or the MIT license or BSD license, those are often very, very simple. So MIT and BSD license are very, very short. It's only half a page of text. And basically, they just require you to cite the original author of the software and nothing else. And this is basically like CC BY. And when to use which software? So if you have something like scripts, like Python scripts or whatever, it doesn't matter at all. You can use GPL or Apache 2 or MIT or BSD, because a Python script is always source code. So if somebody wants to sell the Python script, they have to sell the source code of the Python script, because it's a scripting language. So there's no real difference between those licenses. But if it's something like compiled software, then with GPL, you make sure that the software source code is always available, while with the Apache, MIT, or BSD license, the derivative work out of it can be closed source. You just need to be mentioned. So this is nice for businesses, and because of that, there are a lot open source projects are using those Apache 2, MIT, or BSD licenses. But it's more important for compiled stuff, where you are compiling the source code to something only binary, machine readable. And in that case, CC BY might not be the best idea, because you want to make sure that the source code of the software is still available, and there the share alike and the copyleft principles are much better. So, but for the typical user in science who is using R or Python script, it doesn't really matter. So basically, you can think of them like the CC BY licenses, and the share alike is only about the licensing of the result, but you don't care about source code availability. That's also important in those software licenses. So and then the software licenses all deal with patents. For example, Apache license deals with patents. MIT doesn't mention patents at all. So that's a problem for some users. And the GPL, as far as I know, also talks about patents, but I'm not 100% sure at the moment. And the last final sentence about it: if you're using software by somebody else, please also cite the software you use to create your data set. So actually, in your paper, you are citing, for example, the data set, and the data set itself cites the software which was used to create that compilation, for example. That's something. So, and that was it for today.